So Section 21. You can still serve a Section 21 if you want to until the 1st of May. But it has to be deemed served by the 30th of April. And deemed served doesn't mean you posted it that day. It means it arrived with the tenant and is the service date. So you can still serve them if you want to, but it must be served on the tenant by that date. Now, don't all leave here and go and kick your tenants out, because honestly, it's not that drastic. But after this date, it's gone. It will be completely and utterly gone, never to be used again as of the 1st of May. Now, I'm going to talk about the new grounds and how we obtain possession, and then I'm going to talk to you about the transitional period. So 1st of May, you can serve it up until then. 30th of April, it must be deemed served. After that, it's gone. So the good news is this then. If you want to sell your property, we can still evict the tenant. If you want to move back into your property or move a family member into a property, we can still evict your tenant. And if your tenant fails to pay the rent, we can still evict your tenant. So let me ask you a question now. Is this really that scary? The new grounds allows us to sell. It allows you to use a notice that you or one of your family want to move back in. We also have a new ground, a new antisocial mandatory behaviour ground, which is brilliant news. Because up until now, we have an antisocial behaviour ground, which is ground 14, but it's discretionary. What that means is, if the judge wants to give you possession, he will, but he probably won't. In 20-odd years, I've never known a judge award on discretionary. Never. I wouldn't recommend to my landlord you go to court on a discretionary because the cost, and you have no guarantee. So that's positive. And rent arrears, there have been a change in notice periods. Now, that was the good news, okay? So we can still evict tenants. But now the bad news. They've extended notice period times, and they've made it a little bit more complicated for you to get tenants out. As we're used to with Section 21, you just serve it. As long as you've complied, you can serve the notice. 2 months, you can get them out. We're not going to be able to do that anymore. Notice periods have doubled. And for ground 1 and 1A, which are probably going to be the most common grounds, 1 is, I think you want to sell your property. And 2, 1A is you want to move back into the property. You are not going to be able to use that for the first 12 months of the start of a new tenancy. So when you move a tenant in on the 1st of May, let's say, for example, the earliest time you can ask them to leave is the 30th of April next year. You have to allow them to stay for 12 months minimum. Now, if you wanted to exercise your right to serve that notice, you would serve it at month 8. So 8 months have gone, you serve them 4 months notice, it will expire 4 months later. So for those 2 grounds, they have what I'm calling a 12-month protected period. So we've got longer notice periods introduced. Back in the olden days in 1988, the tenant had to be 3 months in arrears before we could issue a Section 8. In 1997, the Housing Act ground was revised, and that was reduced to 2 months. Well, in the wonderful year of 2026, we're going back to 1989, and now a tenant is going to have to be in 3 months rent arrears before we can activate a notice. At the moment, we only have to give them 2 weeks notice. So, tenant doesn't pay their rent for 2 months. We serve a notice, Section 8. We are intending to evict you. We leave it 14 days, and then we can serve court papers. That's current. What we're going to have to do in New World is wait until the tenant is 3 months in arrears. We are going to have to serve 28 days notice, so double, and then we can start the court process. So we're effectively taking it from 2.5 months to 4. Now, I can't do anything about that. I wish I could. It's crazy. It's stupid. And there's also a little caveat in the guidance that I'm waiting for clarity on that also says if the tenant's benefit hasn't been paid or they're waiting on payment from Universal Credit, then we won't be able to use the ground. But I'm not going to get into that mess because I don't have all the answers. I'll come back to you on that one. But they are extending the allowance of rent arrears. Now, all I can give you as advice here is this. Get rent guarantee. Please, please consider rent guarantee on your portfolios right now if you can't handle the financial loss of a tenant not paying their rent. Because in the current status as to where we are now, it is about, in some cases, anywhere between 4 and 8, 9 months to get your tenant out, depending on where you are in the country. But it's a long time, the whole process. That could be longer because they promised us under a blue government that they would reform the courts before they got rid of Section 21, and they haven't. Section 21s don't need to be heard in a court. They're dealt with through the post. Section 8s will need to be heard in court. There's talk of a digital court system. I don't know enough of it to explain that scenario, but that's what they're saying. We shall see. But what I'm saying to you is if you can get rent guarantee now, do it. Because it's not costly and it is likely to protect you in the future. The 12 months is from the date of the start date of whatever the tenancy is now. So if a tenant moved in, 2 years ago, free for all, you can do it right away, 4 months notice. Yeah? If the tenant moved in January, you can't serve it until August to expire next January. So the 12-month clock effectively starts ticking from the first date of the tenancy. Does that make sense? We sell out our rent guarantee insurance. I think it's £30 plus VAT. That might go up slightly. Who knows? The rent guarantee providers are putting their prices up because they're going to be in for a big payout. They're taking all the risk. For me, 30 quid a month on a £1,000 property or on any value of property, what you've got to understand is most rent guarantee policies now will cover you for about 15 months rent, all of your legal fees, all of your court fees, and all your bailiff fees. Now, a court fee alone was £355. I think that's just gone up to £410. A bailiff fee is about £150, £180. I think that's gone up. Your solicitor representation fees are going to be God knows how much because it depends how many times they have to go to court with you. And then all of the loss of rent. For me, it's a no-brainer. If you're a self-managing landlord, you need to search for a provider that will provide to self-managing landlords because we're an agent. We have a bulk policy and they're a bit more lenient because they trust us agents more than self-managing landlords, sorry. For once, we're in the good books. Section 21, you don't need no reason. You just serve a notice and that's it. There's no reason. But in Section 8 world, you will have to prove that you are going to sell the property. And this is really important, guys. Once you have used that notice to say to a tenant, I am going to evict you because I want to sell, you cannot relet that property for 12 months. You cannot relet that property for 12 months. So it may well sit empty if it doesn't sell. And that's the bit I think they've got utterly and completely wrong. Because 12 months is too much of a long period of time to expect a owner of a property to go without revenue. And I think this is where we're going to find people breaching the laws. So the restricted period is for 12 months if you use the ground for sell or for move back in. You cannot relet it for 12 months thereafter. £7,000 fines and all sorts of prosecutions if you decide to go against it and remarket it and move another tenant in. If you use that ground, you have to have evidence that you intend to sell. You can't just say, I'm kicking you out because I want to sell. You're going to have to provide some sort of proof. Now, the suggested proof so far is a signed contract with an estate agent. I'm like, well, that's not worth the paper it's written on because you can withdraw it at any time. Or an offer on the table. Well, you might not have even been able to get a viewing because your tenant's playing hardball and won't let you in. So we'll have to see what this evidence looks like. But yes, you can market it during that period. The only caveat to that is if you've got a bad tenant, they're not going to let you in and do viewings. One of the things that people are saying is talk to your tenant. Speak with your tenant. Reason with your tenant. Try and get your tenant to leave without using Section 8. Now, if we have to pay them 500 quid, well, or so be it. We'll help you with your removal costs or whatever. You have to think what is best for you. Because if you paid somebody 500 quid to help with their removal fees and they moved on, and you tried to sell your property and you failed, you can relet it in a month or so with no penalties. The moment you execute the right to use that notice is where your restriction on reletting it comes into play. So if you can get mutual agreement, It's always better. And we're talking here like all tenants are horrible. They're not. There's lots of tenants that are very reasonable and understand moving on. Now look here, £40,000 penalty if you let your property within 12 months. So letting agents are going to start asking questions now. Please bear this in mind. This is not us being nosy. When we come out and take properties on for landlords, we're going to have to ask them, are you in a restricted period? Have you used the ground 1 or 1A in the last 12 months? It's going to be part of our due diligence because we can be fined for marketing your property if you've used that ground, because we have to do due diligence too. So just bear that in mind. If we're asking more questions than we do already, that's the reason why. So this is really important, and this is going to be vitally important in New World, okay? Evidence. Evidence that you've got the correct deposit protection, that you're registered on the new property portal once it's in force, that your safety certificates are in order, that the compliance pack was complete, that communication records are maintained, that arrears records are maintained. They are going to expect evidence from you when you are trying to evict a tenant. Remember, they're trying to make it harder for you to evict. They're not trying to make it impossible, but they are trying to make it harder. Evidence is key. So I'm just going to talk to you about transitional arrangements. And if you've served a Section 21 before the 1st of May 2026, the notice can be used up to 6 months from the date of service or until the 31st of July, whichever is the sooner, okay? So if you serve it in April, you haven't got 6 months. If you serve it in April, May, June, you've got a month to act on that as soon as it expires and get that paperwork into the court. Because if your paperwork isn't in court by the 31st of July, it will not be looked at, okay? So that's really, really important. Because if it's not in the court on time, Section 21 will become invalid, and the only route to possession is going to be through Section 8. So Section 8 notices, okay, that have been served before the 1st of May, because there's 2 types of notices, because the Section 8's changing, can be used up to 12 months from the service date or by the 31st of July 2026. Now remember, the current rules for Section 8 are the tenant was 2 months in arrears when you serve the notice, and they are in 2 months arrears when you get to court. The judge has to give you possession. We also still will use in the New World the grounds that we use in the current world, which is ground 10 and 11, which are both discretionary grounds, but it allows us to get possession of that property even if they turn up at court and pay rent, because I have had that happen too. A tenant has turned up to court with a carrier bag with every penny that they owe and paid rent. So our mandatory ground had gone, but we'd got discretionary grounds and we were awarded a suspended possession, which meant if they failed to pay the rent again, we could just automatically evict. So these are the timescales from here. Now, after the 1st of May, if you serve a Section 8, using rent arrears grounds, that also lasts for a period of 12 months or until the arrears are cleared. So if somebody's in 3 months rent arrears, you serve a Section 8, they pay them all off and then don't pay you again for another 3 months, you have to serve a new Section 8, because that new one, the one that you serve, the minute the arrears are cleared, it becomes void. Judges don't offer discretion now, and I remember one time I was in a court, and it was Wolverhampton Court, and we sat in front of a judge, and I was there with the landlord when we were able to go. Unfortunately, the landlord, who's a really professional landlord, been in the game for a long time, was in financial difficulties. He was going through a bad patch, and there was multiple of his properties that he was in arrears on, and he had this one bad tenant that wasn't paying the rent, that of course wasn't helping his financial predicament. In the court, I politely asked the judge, can I talk to you about the landlord's financial position? Because we were sat there talking about the tenant's financial position, who was sat in court lying, saying she'd made rent payments when she hadn't, and the judge shut me down dead and said, no, it's not the time to be talking about the landlord. That's not what we're here for. Judges do not really give possession unless they have to. I did get a good judge just after COVID when we went to court. The judge said we'd done the notice wrong, but we hadn't. That was the second judge I had to ask to, reconsider his decision. But because the tenant on this one hadn't turned up and the tenant was 15 months in arrears, the judge still awarded me possession even though he thought my notice was wrong on discretionary grounds, because he could see that a tenant that hasn't paid rent for 15 months has bad intentions. This isn't just an accident. But when tenants are in court, remember what they get? Free legal aid in the court. They get the help from the people that are there. So you have to bear that in mind.